Inside Texas Politics, 3rd edition by Brandon Rottinghause, Chapter 11, Part 2. 11.4 Life After Prison. After their release, persons with felony convictions may face collateral consequences by being banned from certain employment, access to benefits, and eligibility for specific programs. Restricted licensing, employment, and access to programs. State law restricts from serving in many state positions, including as a railroad commissioner, a primary election judge, and several hospital district boards. Felons are also ineligible for food stamp benefits, selected Medicaid programs, and higher education scholarships. Almost 200 certificates, permits, or specific types of employment are not available to felons. These includes a license to sell alcoholic beverages, to serve as director at a child care center, and to conduct charitable bingo games. Voting rights. Another significant collateral consequence is the loss of voting rights, called criminal disenfranchisement. Close to 6 million Americans are unable to vote due to felony disenfranchisement policies. States may suspend voting rights while if the felon is in prison only. During parole and probation as well, or even for years after the sentence has been served. See figure 11.6. There is a racial disparity in the voters who are disenfranchised. Nationally, 1 out of 13 African Americans has lost voting rights compared to 1 out of 56 non-African Americans. Parole. As the famous country musician Merle Haggard wrote in his hit song Mama Tried, some Texans turned 21 in prison doing life without parole. A prisoner earns parole through good conduct while being locked up. Points are assigned based on effectively carrying out assignments, attempting to rehabilitate, and generally exhibiting good behavior. See Table 11.3. Except in cases where prisoners are not eligible for parole, such as those on death row, parole becomes an option when their calendar time served plus good conduct time equals 1/4 of the maximum sentence, or 15 years, whichever is less. Depending on the case, the standard for parole may be higher. At the high point of parole granting in the 1980s, inmates served approximately 22 days for each year of their sentences. Jail overcrowding spurred the state to release convicts like Kenneth McDuff, who served only 20 years for a violent triple homicide while on parole. McDuff kidnapped and killed a Waco woman in response to this and other heinous crimes committed on parole. The state instituted minimum time served requirement before the parole could be granted. The parole rate came down dramatically from 80% in 1991 to 50% in 1992 and to 20% in 1994. The parole approval rate for 2018 was 33% for the state overall. Still, 2/3 of the Texas pardons and parole board members must vote yes to grant parole in capital offense, making it difficult to achieve. (11.5) Reforms. Criminal justice reforms in Texas are often punitive in nature. One observer joked that when the legislature meets every 2 years, the first thing they do is increase the penalties for everything. Historically, Democrats and Republicans have been equally hard on crime and criminals. Democratic Governor Del Briscoe, 1973 to 1979, railed against long-haired weirdos, made vigorous enforcement of crime a major issue, and pushed a hulking anti-crime package through legislature. Republican Governor George W. Bush, 1995 to 2000, increased punishment for juvenile offenders and pushed truth in sentencing, laws to limit parole options. The question is how to balance the generally tough on crime approach with the requirements for a just system and controlling costs. The lock them up and throw away the key crowd has given way to bipartisan efforts to come up with creative solutions to reform the criminal justice system in Texas. Alternatives to incarceration. On an average day, Texas county jails house about 65,000 individuals. Many of these incarcerated individuals are low-level, nonviolent offenders, especially those with mental illness or substance abuse problems. Both state and local governments have implemented strategies to provide alternative solutions for these specialized jail program populations. One county sheriff rewarded positive inmate behavior with good time credits. A legislative pilot program for offenders with mental issues was initiated in 2013 to reduce repeat criminal behavior, limit time spent in jail, and expand clinical mental health and social support services through rehabilitation programs and residential housing opportunities. However, overcrowding and inmate deaths have remained a problem. Bail reforms. Most prisoners in Texas and across the United States have not been convicted of any crime but remain in jail because they cannot afford to pay bail. In 2001, 39% of inmates in Texas were pretrial detainees. In Travis County, Austin, that figure was 75% in 2017. Each prisoner costs taxpayers about $51 a day. Posting bail is especially burdensome for low-income defendants who cannot get back to work, support their families, and aid in their own defense. The rigid predetermined bail schedule does not provide enough flexibility. Reformers argue to ensure that the bail is fair. Reformers also argue that the court system can use statistical tools to improve the manner used to determine the risk of flight, which bail is supposed to reduce, rely less on financial bonds, and ensure that the defendants have a bail hearing within 24 hours of their arrest. In 2019, following a U.S. District Court judge review of Harris County case, a landmark agreement was reached establishing an automatic no-cash pretrial release for about 85% of low-level defendants, more funds for overworked indigent defense attorneys, and better access to social workers. Dallas and Galveston counties have similar lawsuits in the works. Addressing prison suicides. Even as the prison populations are falling, Texas prisons witnessed a 140% increase in suicides from 2013 to 2018. With 40 suicides occurring in 2017 alone, more than 150 inmates attempted suicide per month in 2017. As one tool to prevent suicides, the Texas Department of Criminal Justice has increased the training of prison officer cadets to spot a mental health crisis in a distressed inmate. Criminal justice reform advocates also stress the need for access to services and more prison staff in general. Grand jury reform. Until 2015, a district judge would personally select citizens to be jury commissioners, and those commissioners would then choose 15 to 20 citizens to serve as the grand jury pool. Critics believe this process encouraged the selection of grand jurors who were more likely to bring charges against a suspect. Indeed, one Houston Chronicle reporter uncovered an instance in which grand jurors actively collaborated with prosecutors to intimidate witnesses. In 2015, Texas passed legislation to outlaw the pick-a-pow grand jury system. The new system institutes a random process for drawing jurors from a broad pool of potential applicants. Death penalty reform. While Texans overwhelmingly support the death penalty, 49% of the Texans believe that the people are wrongly convicted of the death penalty. Occasionally, and 13% feel this happens a great deal of the time. This sentiment is backed by a concrete evidence. The Innocent Project, a national organization dedicated to exonerated individuals wrongfully convicted using DNA testing, reports that 52 individuals in Texas and 362 nationally were exonerated as of 2018, more than any other state. Carrie Max Cook's fight is one example. Arrested in 1977 for the rape and mutilation and murder of a woman who lived in his apartment, Cook endured a 40-year ordeal, including conviction for murder, 3 trials, 2 death sentences overturned, and freedom from death row in 1997. While in prison, he was repeatedly raped and stabbed, abuses that led him to attempt suicide twice. In 1998, DNA tests revealed that none of the evidence collected at the scene of the gruesome murder belonged to Cook. Another man, the victim's lover, a married man, was linked to the evidence at the scene. Cook agreed to a plea deal that dropped the murder charges and allowed him to get out of jail, but not legally exonerated. Even after 4 decades, Cook is still fighting to clear his name. Winning could mean compensation of up to $2 million from the state, including health and education benefits. In the last 25 years, the state has paid wrongfully convicted men and women $93.6 million. DNA testing of evidence in criminal trials holds a great promise to identify persons responsible for crimes, yet it is not always reliable. The Texas Forensic Science Commission introduced new standards on mixed DNA evidence when more than one individual's DNA is found on evidence. Other procedural safeguards can also be employed to make the system less fallible. Civil rights organizations have outlined dozens of recommendations to reform the death penalty in the United States. First, states should require review of credible claims of innocence even after conviction. Second, all evidence should be preserved for an extended time after a conviction, and DNA databanks established to keep records, to which defendants should have access. Third, parameters should be established to ensure reliable testimony from eyewitnesses, including in jury instructions. Fourth, states should create an independent authority to screen and train defense attorneys representing clients charged with capital crimes. Finally, because the death penalty is disproportionately applied to racial minorities, states should pass legislation to ensure racial and ethnic diversity among the judges, lawyers, and jurors so that no racial discrimination plays a role in the punishment. Although Texas is undeniably aggressive in using the death penalty as a sentence for capital crimes, the state has also led the nation in efforts to improve procedures in such cases relating to police practices, forensic evidence, and prosecutorial procedures. Legislation was passed in 2017 to improve law enforcement lineups, require that any testimony of jailhouse informants be corroborated, and guarantee a defendant's right to DNA testing after conviction. The insider view. Historically, state political officials, often responding to public outcry for retribution against crimes, have been punitive and harsh. These efforts have trickled down into prison policies, sentencing policies, and punishment, but they are often countered by voters who have grown weary of spending funds on prisoners. In response, public officials have implemented reforms that have reduced the state's incarceration rate, dropped the state's crime rate to pre-1968 levels, decreased the number of repeat offenders, closed 8 prisons over the last 7 years, and cut the number of death sentences and executions in half over the last 2 decades. Many problems still remain, however, such as prisons overcrowding, racial disparity in sentencing and incarceration and treatment of prisoners. This is the end of chapter 11, part 2.